Bonjour. Mizanagijik, Indigenous Higodode. Iswain Medeo. I want to thank the Coast Salish people for the warm welcome that we've received here, and the organizers of this event for inviting me to be here to speak with you. I was going to bring my laptop computer up here and work with my notes that I have on it. It is actually it's a traditional computer. I want to assure you of that. I was at a conference not so long ago in which I was all set up with my laptop and ready to do my presentation, and an elder decided it was at that point that the room should be smudged, so he went around the room and smudged everybody and everything, and he smudged my computer. So my computer is now sacred. I have the only sacred computer among the judiciary in Canada, I think. I do have some thoughts to share with you today about two things. One is the nature of the relationship between Aboriginal people and the justice system, and in particular a look at the way things are and why we are at the stage that we're at. And secondly, I want to talk to you about the experiences we've had in Manitoba regarding the issues surrounding that relationship and the implementation of a restorative justice approach, particularly in light of the Gladue decision. But I do also want to acknowledge the fact that some of you who I've met before will have noticed that I have cut my hair. For a long time I wore a braid. Kathy Lewis remembers me when I was a braided judge, the only one in Canada, I'm sure. But about a few years ago, an adopted brother of mine was lost in a car accident. And as a result of that, in keeping with our traditions, we cut our hair for him. Thank you very much. That's fine. And I had intended on growing it back because it was the first time in the lives of my children they'd actually seen me without a braid. They had never, ever seen me without long hair. And in fact, when I came home one day after the ceremony in which we cut our hair, they all collectively looked at me and said, "Dad, you look just like Grandpa." So I knew then that maybe I should try to go back to the way things used to be. But unfortunately, I'm at that age where growing hair is not as easy as it used to be. In fact, I've entered that age in life in which God has shown how much He hates men and loves women. When women enter the middle age, they become beautiful and dignified and glamorous in the sense that the respect that we have for women is magnified by the fact that they are now gaining status in our eyes as aunties and as grandmothers. But us men, we are relegated to the fact that at this stage in life, the Creator pushes our hair back into our heads. And unfortunately, it comes out our ears and our nose. And so I've entered that very difficult phase of manhood. I was going to, as I say, bring my computer up here to work with my notes, but I have done a presentation similar to this so many times I don't really need it other than as a crutch. But I have a much better one now. My friend Kathy just asked me to carry this up here. So I want to acknowledge this wonderful gesture that she has made to me to ask me to have this with me when I talk. It is, of course, in keeping with our traditions that we honor those symbols and those acts of kindness that are done for us like that. I am one of the few professional people that I know of back in Manitoba who still works closely with the traditional things. It's a very difficult process. It is for me, and I'm sure because of those difficulties, it has been for others to try to do that. And I spend a lot of time talking with particularly lawyers in training in law schools and in the bar admission processes, the Aboriginal lawyers in particular, and spend time with them talking about how one balances one's spirituality and one's profession. Because it's easy to think that they are distinct, when in reality they are totally immersed in each other. The important thing is to recognize that immersion, and recognize that amalgamation, and to see how you can work with it in the best way that you can. We are all influenced by those things that are around us in ways that are unexpected and are often uncontrolled by anyone, but by everyone. And so I'm going to talk about that as well. When I went to law school in 1976, I had great ambitions about things. My ambitions for my life were the ambitions that I had for society at large, and that was that I saw a world in the future in which Aboriginal people and the issues that they presented would be treated fairly and justly and appropriately. I didn't have a great idea about how that was going to end up looking. I had these amorphous visions that strung through my brains as I thought about them, but at the same time I knew that the way things were not the way things should be. But my ambitions for my career lay primarily in the field of politics. When I went to law school, it was to be a politician. I entered law school because I saw, as you heard in my work as an assistant to the Attorney General of Manitoba, that the career, the profession that was most represented among the politicians that I worked with was that of a lawyer. Lawyers in law degrees, I thought, and still think to a certain extent, give one an aura of instant credibility. You can invite a lawyer to give you a presentation about whether Dodges are better than Fords, and because he's got a law degree, you instantly believe what he says. So having that law degree just seems to give you a measure of status in terms of the presentations that you make. You can be the dumbest person in the world, but if you have a law degree, then that overcomes a lot of stupidity, at least in the eyes of the receiver. So taking that into account, I thought being a politician was a natural career with a law degree, and so I went to law school in order to become involved in politics. I was still of that mind when in law school I became involved in learning about the litigation process, or the court process, as we call it. And as you heard, I was quite interested in learning how to do court work and won the prize in law school for that course. But the end result was that after I finished law school, I decided, well, before I got into politics, I was going to go and be a lawyer for a while. I loved the courtroom. I still do. I loved going to court. I loved watching the process. I loved seeing how people worked the system. I loved the rules and understanding the rules and learning how to use the rules. I come with a mindset to things that needs to understand how things are done and why things are done, and learns how to use that kind of a system. So I'm not of a mindset that works well in an undisciplined environment. I'm a particular kind of a personality. So because of that, the law school process and the litigation process really appealed to me, and I liked the courtroom setting. So I decided to go to court as much as I could. So I did. Even though often I wasn't involved in any cases, I would still go down to court just to watch the trial process, to watch lawyers do their work and listen how they examined and cross-examined witnesses, and hear what judges said and how they did things. Because the one thing that was apparent to me from the very outset of my legal practice, and from the outset of my legal training, was that Aboriginal people were greatly overrepresented in the criminal and child welfare systems. And those were the areas that I wanted to work in. So I thought in order to help them best, I needed to understand how that system worked as well as I could, so that I could use it in the best way that I knew how. So I did as much as I could to learn that and to understand that. And when I started practicing law and working as a lawyer, I immersed myself totally in the things that my clients were involved in the problems that they had, in the situations that they presented, in order to figure out a way to tell the judge and to tell the lawyers, particularly the lawyer on the other side, to persuade them that the situation that my client presented required a degree of understanding that had not been brought to cases that they may have held in the past involving non-Aboriginal people. What I was trying to do was without knowing it, to persuade people to approach these cases differently and to understand more about the systemic and background issues that were at play in order to appreciate the circumstances that these individuals presented. That was and is a difficult thing to do, particularly when one comes from a background of training that all lawyers have, in which we are told things and in fact required to hold those things on faith. We are told, for example, about the jury system and the beauties of it and how wonderful it is, and we are required as a result to accept on faith that that system is going to work. We are told about the English common law system and the principles that evolved from the common law, and we are told and required to accept those principles on faith without necessarily understanding why or how those principles developed. And what I was trying to do as a young lawyer working in the field of criminal and civil litigation, and in particular child welfare and criminal law, was I was trying to persuade members of the legal profession, judges and lawyers, that what they had accepted on faith to that point in time was not necessarily correct, and that what they needed to do was to accept other things on faith as well. They needed to accept other things from the perspective that we can't explain totally how and why these things are, just accept that that's the way things are and that they are valid. And that proved to be very difficult. It proved so difficult, in fact, that after about a year of trying that, I decided to quit. I decided to quit being a lawyer, and in fact, I decided to quit being involved in the legal process at all, even in terms of being a politician. I was frustrated. It was my view that the legal system was never going to change, and I was never going to be one involved in changing it, and therefore I felt I was betraying myself, my family, and my community by continuing to remain involved in it. So I decided to quit as being a lawyer. I went to, I remember when I told my wife that, she was not at all surprised because she, of course, had seen the level of frustrations I brought home every day, and she was not happy with the way that it was affecting our lives. But she said, before you make a decision like that, before you do anything, it's important, I think, that you talk to people in our community and ask them, first of all, if that's the right thing to do, and secondly, maybe if there's something that you should be considering. So with some reluctance, because I'm essentially a stubborn person, I decided I would do that, although I thought I'd made up my mind. I talked to a number of people, and they all suggested, without exception, they all suggested that I should go and talk to a particular elder, one who had experience with the justice system, and one, in fact, who was well respected as also a traditional man who understood our customs and our teachings, a fellow by the name of Angus Merrick. Angus, at that time, in 1970, that was late 1979, early in 1980, Angus would have been in his 70s. He has since passed away, but at that time was a very wonderful, kind, spiritual fellow. But he had spent all of his working life, since he had stopped working as a farmhand in his 30s or so, he had spent all of the rest of his working life until his 70s working as a court worker in Manitoba, working within the justice system. So he understood the system. He understood what it did, he understood how it did things, and he understood, to a certain extent, why. And so it was logical, I guess, that I went to speak with him. So armed with my tobacco and my time, I went to speak to Angus. I called him up and I said, I'd like to spend some time with you and talk about something. And he kind of knew what it was because he said, oh, we have to spend a lot of time together, he said. So come out here tomorrow morning, he said. Come out early as you can. So I went out there to his place and I got there early in the morning. And as soon as I arrived, he said to his family, he said, now you have to give us some peace and quiet, he said. We have to talk, he and I. and we spent all day together. We talked. He took me outside to a teepee that he had in his backyard, and he lit a fire, and we sat there and we talked, and he made tea. We drank lots of tea, and he smoked the tobacco that I gave him, kept rolling it into cigarettes and smoking it while I talked. And I talked all day. And whenever there was a pause and I had run out of things to say, he would sit there quietly and wait until I started again. And by the time I had finished talking and he began talking, it was late in the afternoon. And what he said to me was rather simple, as it turned out, but also very complex. He said, if you don't want to be a lawyer anymore, he said, that's fine. He said, that's your decision to make. And if you're not happy at what you're doing, you shouldn't keep doing what you're doing, because it'll hurt you. So don't do it if you don't want to do it, he said. But the problem, he said, is that you're trying to be a lawyer. He said, you're not trying to be a human being. You can't be a lawyer unless you're a human being first. And what you have to do is you have to try to become a human being first. And what I mean by that, he said, is you have to understand that as a human being, he said, your life will last this long. And he picked up a stick that was about that long, the width of his shoulders. And he held that stick up and he said, your life is about that long. And he said, and for this long, he said, you're a young man living in the care of your family. And at that point, he said, when you leave your family, then you have to become an independent man. You have to become an independent person. But that's a hard thing to do, he said. So that's why we get married. Because being independent doesn't necessarily mean that we are alone, but we need that help and we need that comfort of another family. So he said, you will become married and you will have your own family. He said, when you have left your home, it is because you have learned how to be a son, you have learned how to be a nephew, you have learned how to be a grandson, and now you have to learn how to be those things on the other side, he said. And what you're struggling with, he told me, is that you don't yet know how to be a father, you don't yet know how to be an uncle, you don't yet know how to be a grandfather. He said, that's really what your problem is about. He said, if you want to be a good lawyer, you have to learn how to be a good husband, and you have to learn how to be a good father, and you have to learn how to be a good grandfather. You have to learn how to be a good uncle and a good brother to all of the people. He said, your problem is that you're trying to be a good lawyer without trying to be all these other things. And so what you have to work on is you have to work on these other things. If you work on that, he says, you might still go back and become a lawyer. But remember this, he said, that you will be a lawyer for this part of your life. And he said, you may even become a judge. This was back in 1980, he said. You may even become a judge. He said, but you will only be a judge for this much of your life. He said, but for all of this life that you have, you will be an Anishinaabe. And that's what's important, he said, is that you have to learn how to be an Anishinaabe. And then if you are knowing how to be an Anishinaabe, then you will know how to be a husband, and you will know how to be a father, and you will know how to be a grandfather and an uncle and a brother. And if you know all of that, then you might be a good lawyer, he said. So that's what it was all about, as I learned. And that really was what my problem was about, because as I look back on my life from that point, and even from this point, I can realize that I grew up in a family and during a time in which we were raised to deny our aboriginality, our identity as Aboriginal people. We were raised, in fact, to believe that nothing that our culture offered us or our people offered us as a people had any merit anymore. We were raised to believe, in fact, that it was our obligation. In fact, it was our responsibility. It was our problem to overcome our Indianness. It was a burden that we carried, but if we carried that burden successfully, then we could become successful despite the fact that we were Indian. That's the way that we were raised, and that's the way that I had been raised. And when I look back at all of the things that I had accomplished in life, and I had accomplished a great deal in my life to that point in time, it was because I had achieved things in order to convince others that I was not an Indian person. At least I should not be seen as an Indian person, which I guess in some eyes, and even today, some people would see that as an admirable quality. But the reality is that it really hurt me. It was hurting me constantly as a human being as I was doing that growing up. It was hurting me to deny the validity of that part of me that was so important and so needful. And it so happened that at about that time that I was going through this struggle, and going through that identity problem, that identity crisis, my oldest son was born. And Igan Weidung was born just as I was starting law school, in fact, when this crisis was beginning to heighten for me. But by the time I was practicing law, he was about 3 years of age. And at that time, I was spending a lot of time with him, trying to play with him and playing with him and trying to help him to understand things and explaining to him about things. And I remember one time he said to me, this was in the summertime before we started classes in the fall, he said to me, "Daddy," he said, "I'm part Indian, right?" And I said, "Yeah." He said, "Mainly Indian?" He said, "Yeah." He said, "Well, I think I know which part of me is not an Indian." And I said, "What?" He said, "I think it's my bum." And I said, "Why?" He said, "Well," he said, "every time in the summertime when I take off my shorts," he said, "my bum is always white." So as he was talking about that, and we were joking a bit about it, I came to realize that I was really not offering him much in the way of understanding who he was as an Aboriginal person. I was not giving him very much. And it was because I did not have much to give him. Because I had been raised in that family that did not have that. I was raised by my grandmother, who was an Ojibwe, and my grandfather, who was a Cree. And we had very strong, in fact, traditional connections in our family. Cree and Ojibwe, as well as French and English, were spoken in our house when I was a little boy. And I'm told that when I was young, the first language I spoke was Cree because of the relationships that we had in our household. But by the time I started school and was sent away to school, that we were told that we would not be allowed to speak that language anymore, both at home by my grandmother, who herself had been raised in a residential school, and by my grandfather, who basically followed whatever direction my grandmother made in that area. So that was the way things were. So while in this day and age I can understand Ojibwe and Cree when it's spoken, I have a hard time speaking it because I don't have that linguistic ability. But I had been raised in that family in which everything of an Aboriginal aspect had been denied to us. But we still used our culture frequently. I can remember as a little boy when I was very sick one time. I had pneumonia, and before my grandmother took me to a doctor, she took me to see this old woman. We called her Granny Cochran. She lived in a house way off in the woods, traditional medicine person, as I've figured out later, whose answer to the problem was anything to do with fish was good, in her view. So as part of their treatment for pneumonia, she wrapped a fish around my chest and then made me eat anything to do with fish broth, fish soup, fish meal, and it cured me. At least my grandmother tells me that, and I believe it. I remember as well one time when I was little, I had a problem with warts on my hands. And my grandmother took me to see Granny Cochran again. Granny Cochran proceeded to treat me by rubbing some raw rabbit meat all over the warts and then wrapped it in a cloth and tobacco and said to me, "Now you go and bury this." She said, "There's a certain spot you have to bury this." She told me, and so I went and did that. And those warts cleared up within a very short time. So I grew up with that kind of respect for those kinds of things without really understanding the why. But when I was a father, when I was faced with the fact that my son was now talking about trying to understand his own identity as an Aboriginal person, I realized I could not give him very much because I didn't understand myself. So I struggled to try to find a way to give him a sense of connection to his traditions. And after spending that day with Angus and understanding what he was talking about and the importance that that had for me, I came to understand as well the importance that traditions and connection to our heritage held for us. Because as growing up, I realized that was always a part of me that was missing. And so at the end of the day, I resolved that I was going to spend time to learn about traditions and culture and figure out where things stood for me. But because of the way that I had been raised and educated, I started out doing it in the way that I had been used to doing things. I decided to do some research. In 1980, if you went looking for Aboriginal books on identity, it's hard to figure out where in the library system you look for that. You look under I for identity, A for Aboriginal identity, A for awareness. The library cataloging system didn't have a section saying, here's where you go if you want to know who you are. They had all sorts of things about history and social studies and things like that. But there weren't a lot of things written about Aboriginal awareness at that time. But I did manage to find some things. And in particular, I found some American writers, and probably the most influential and probably the most dangerous for me to read at that time was a fellow by the name of Vine Deloria. Anybody who's ever read American Aboriginal literature knows about Vine Deloria, a very prominent activist American writer, Aboriginal writer, who is also very outspoken about his views insofar as the relationship between Aboriginal people and the state is concerned. But one of the things that his writings and how his writings influenced me, and I read everything that he ever wrote, I still do whenever it comes out. One of the things that his writings influenced me on was the importance of understanding how relationships evolve between states, between nations. And what he pointed out in his writings, particularly in books such as Custer Died for Your Sins or the Indian Manifesto, was that you can't understand the way things are unless you know how you got there. You can't understand why things are the way they are unless you look at the way that the relationship has evolved. And so the first thing that he says you have to do is you have to look at the way that the way in history that things have developed so that we get to this point in time. Because if you understand how we got here, then that will help you understand how we get away from here. What we have to do to undo what we have done. You cannot undo what we have done unless you know how we have done what we've done. That's essentially a simple formula when you think about it, but it was one that I had a difficult time appreciating until I read some of his work. So armed with that information, I decided, well, I then need to understand why things are the way that they are. And this was in keeping as well with the feeling that I had of great guilt about my family. Because when I came to realize how little I knew about my culture, I became angry at my family. I became angry at my grandparents who had raised me for denying me a connection to my history, for not teaching me and not allowing me to keep contact with my languages, and for denying us contact with traditional people on an ongoing basis, for forcing us to go into the Christian churches and the Christian faith. And so that anger was still part of what I was living with. And that anger became guilt when my grandparents passed away around the same time. So a lot of things were going on for me, as you can see. So that guilt was still part of me because I had not resolved my anger with my grandparents before they had passed away. And so I decided I needed to understand why things had become the way they were. One of the things that I had come to appreciate in my family was the role my grandmother played. She was the most influential person in our household. And that had been a deliberate pattern that had been set by both my grandfather and my grandmother. My grandfather often used to tell the story about how they had become married. He had been married before. He had a first family, and his first wife had died during childbirth, and so he was left with 3 little children to raise. And as a working man, he was unable to do that. And the restrictions of the Indian Act at the time prevented him from moving very easily. So he had gone to see people in his community to see if they could help him to find a new wife. This was back in the early part of the 1900s. And so he was eventually directed through the various contacts in his community to go and talk to the sisters who ran the residential school, because the sisters who ran the residential school had a program that was not widely publicized, but was well known within the community anyway, that if you were a Christian Indian and you were looking for a wife, the sisters would find a wife among the girls in the residential school for you to marry, because they didn't like the idea of those Christianized girls who they had raised in the convent going back to their communities and marrying these pagan Indians. So they were quite attracted to the idea of marrying a Christianized Indian girl in the residential school to any Christian Indian who came along looking for a wife. The basic rule was you had to be a Christian Indian. My grandfather had been raised an Anglican, so he kind of wondered if this was going to be a hurdle, whereas an Anglican to go to a Catholic convent and ask them to allow him to marry a Catholic girl. So he says he went there anyway because he couldn't find any other person willing to marry him. This kind of makes him sound desperate, but that's not quite this. Just because my grandfather was a very shy man, so he didn't quite have the ability to romance women very easily. So he says he went to the convent and he kind of made his application. He let it be known to the sisters there that he was looking for a wife. And so they actually brought 3 women to a room, he said, to introduce to him, and kind of said to him, make a choice here. And so he says he chose my grandmother, and that's how they got married. My grandmother tells it differently, incidentally. My grandmother's version is that she chose him, and that she was the one who was given the option by saying, there is a man here who is interested in finding a wife. Take a look at him, and if you like him, you can marry him, if you want. That's the way she tells it. So either way, they got together. The marriage was arranged in that way. But my grandfather says that it was very clear to him, made very clear to him, that if he was going to marry this Catholic girl, that he had to agree to a number of things. One of them was that he had to agree that all of the children would be raised in the Catholic Church. And he had to agree that he didn't have to agree himself to become Catholic, but he had to agree that he would continue to attend church. He would continue to be a Christian, that he wouldn't give up his faith, and that the household would be a Christian household. And he had to agree that all of the decisions about the raising of the children would be left in the hands of my grandmother. So those were the terms and conditions of his arranged marriage. So he agreed to that. And so that's how their marriage was arranged. And that's why in our household my grandmother was very influential. She had the control right from the beginning. And she was very influential about the way things occurred. And when she made the rule, that's the way it occurred in our household. So I grew up in that kind of an environment with that kind of respect for women. But it wasn't always that way. From around me, I could see that respect for women was not there in many other families. In fact, it was quite different. And I tried to understand that as well, because in my practice as a lawyer, in that short time that I practiced as a lawyer, one of the major issues that I was contending with was Aboriginal men who were charged and accused of beating up their members of their family, not just their wives, but their children as well. But I came to, in that guilt that I had about the anger I had about my grandparents and the way that I was raised, I came to understand something, and that is that they were as much victims of the way that things had evolved as I was. I came to understand, for example, that when one looks at the way that law has developed in this country and the way that it has been used to oppress our people, one can appreciate just how difficult it was and has been for our grandparents and, in fact, our parents to raise families in this environment. And when one looks at what happened around the time of Confederation, for example, and the development of the first Indian Act of Canada, and the provisions, some of the provisions that were in the first Indian legislation, you can see that those provisions were really intended to limit the rights and the opportunities that Indian people otherwise might have had. In Manitoba, for example, most people are not aware that until the 1890s, Indians in Manitoba had the right to vote in all elections. And that's true generally throughout Canada. The right to vote was only taken away in the 1890s in most jurisdictions, but in Manitoba and in other jurisdictions, Indians had the right to vote. And Indians also had all of the rights of other citizens in Manitoba until legislation started taking it away. Now, the Department of Indian Affairs did not have that view about Indians. Right from the very beginning, in fact, the view that the government of Canada took towards Indians was that they were to be treated as wards. They were to be treated as dependents, people who had no independence outside of that was given to them by their trustee, the Queen. And that view of things permeates everything that went on between the government of Canada and Indians in Canada throughout the 19th and 20th centuries. When Manitoba entered Confederation in 1870, the first Manitoba Act had certain provisions in it which provided that everybody who lived in Manitoba at that time and who occupied and had cleared a certain piece of land, they were entitled to a grant for that land, in other words, a title to that land as a result of their prior occupation. It's Section 32 of the Manitoba Act. And it was presumed by the Department of Indian Affairs that that provision would only be applicable to white people. But in a case called Sanderson versus Heap, an Indian actually went to court to challenge a white man who took some land that he had occupied and developed. A fellow named Sanderson, who was a member of the St. Peter's Band, had gone fishing for the summer out on the lake, and when he came back, he found that the land that he lived in, of course, in keeping with our traditions, the whole family went out to the lake, to the fishing camps, and stayed there for the summer. And so the land was left vacant and the house was left empty. When they came back, they found that their house had been knocked down, a new house had been built, and a white man was living there. A white man had been put in occupation. And so the Indian went to court, and he said, this white man cannot keep this land because it's my land. And it's my land because I had occupied it before Manitoba's Confederation, before Manitoba entered Confederation, and therefore I'm the one who's entitled to a grant for this land, not him. Mr. Heap, who had argued the other side, who was the recipient of a grant under the Dominion Lands Act, argued, well, I applied for the grant and I was given it, and therefore I'm entitled to the land. But the court said that Indians under the Manitoba Act are just as entitled to grants for the land that they've cleared and occupied as anybody else is. Even though they're also entitled to live on a reserve, that does not limit their right to hold land outside of the reserve. And in fact, if you look at the first Indian legislation in Canada, it specifically says that Indians can hold land outside of the reserve, but they are subject to all of the laws applicable to everybody else if they do so. So Mr. Sanderson won his case, much to the chagrin of the Department of Indian Affairs. So in 1874, the Department of Indian Affairs passed a law that said that if you're an Indian in Manitoba, and in the prairies generally, but just in Manitoba because of the Manitoba Act, if you want to own land outside of the reserve, you have to enfranchise first. You have to give up your status under the Indian Act. And if you don't give up your status, you're not entitled to own land outside the reserve. Even though Indians in the East could do that, but Indians in the West, they amended the law to respond to the Sanderson and Heap case to take away the rights of all Indian people to own land outside of a reserve. So that was kind of the beginning of how laws came to be used to deal with Aboriginal problems as they saw it, or problems that Aboriginal people presented. In the 1880s, we know, for example, that at that time the residential school system became a popular tool. The government had decided that by that time that the residential school system was the way to go insofar as educating people were concerned, even though when you look at all of the treaties promised that the government would build a school on the reserve. The government's response to that obligation was in fact to build schools everywhere else but on a reserve and move the Indians there. And so the residential school system became the tool of choice to take children away from their families from the age of 5 up to the age of 17 and require them to attend a school chosen by the Minister of Indian Affairs was the law of the country. It's easy for us to minimize the impact of that because we're all now quite familiar with the public school system and the mandatory attendance at school by our children. Everybody has to go to school from one age to another age, we know that. But mandatory school attendance for the rest of society didn't become the law until the 1940s. But for Indians, it was the law from the 1880s. And of course, it wasn't a school of choice. We didn't get to go to school where we wanted. We had to go to school designated by the minister. Of course, the minister sent half the kids to Protestant schools, half the kids to Catholic schools, because that's the way that the system developed, at least in Manitoba. Had to maintain that balance, after all. And so the kids were all taken away and sent to schools. Well, a lot of Aboriginal parents, a lot of Indian parents were not actually opposed to the idea of their kids going to school. In fact, that's why the provision was in the treaty. They wanted their kids to receive an education. We know that. My grandmother's big push for me as I was growing up was that I had to get an education. It was the same for all of our children. I had 2 aunts who were teachers. That's another influence that I had in my life. Growing up, which is why education was a big deal in our family. But also my grandfather, who himself had only a grade 3 education, he used to say, getting an education is very important. He used to tell me, in fact, he said, there's only 2 jobs in this world. He said, one, that you wash your hands after you've done them, and one's where you wash your hands before you do them. He said, that's the kind of job you want. That second one, that's the kind of job you want, because that's the easier one and it pays more money. That's what he used to tell me. So, but he said getting an education is very important. So they were both very influential that I should go and be sure to get that education. When the kids were taken away, some parents, though, objected because they didn't like the kind of schools that the kids were going to. And in fact, some of the children objected because we know some of the things that went on in those schools. And when the parents heard about some of those things, you can imagine what it would be like if your children were taken away from you despite your unwillingness for that to happen, but you were prepared to go along with it. If you heard that your children were being abused in that way in those schools, then undoubtedly as a parent you would want to do something. And there is clear evidence that Indian parents, once they started to resist the idea of these children going to schools, started to do so actively. One of the first things that was done was they would go to court to see if they could stop this from happening through litigation. So the government of Canada responded in 1883 by amending the Indian Act to say that no Indian could go to court against the government of Canada unless they got the permission of the Minister of Indian Affairs first. Well, if you want to sue the Minister of Indian Affairs, and first you have to get his permission to sue him, what's the likelihood he's going to give his permission? It's not very likely. And in fact, there's no evidence that any cases were permitted to resist, particularly residential school cases. So if you don't have the right to go to court, maybe one of the things you can do is you can get a friend of yours who's not limited in that way, who's not an Indian. Maybe you could get a friend of yours to go to court to challenge this system. So there's all sorts of examples, particularly in Manitoba, of friendship societies, as they were called, Friends of the Indians, to start these societies with the primary purpose being to lobby for change and to litigate cases on behalf of Indians to get the laws changed and to get the laws struck down. The government of Canada passed another law. It said not only could Indians not go to court against the Minister of Indian Affairs, but nobody could go to court against the Minister of Indian Affairs unless you got the permission of the minister to begin with. And so that amendment went through. So nobody could litigate these laws. So one of the main avenues of civil resistance that we have as a society was taken away from Indian people very early on, and that is the right to go to court in order to discuss a grievance against the government of Canada. They were guilty of a conspiracy. They were guilty of a conspiracy. Now, that became known as the Indian Conspiracy Laws. The Indian Conspiracy Laws were in response to the Saskatchewan Rebellion in 1885, which resulted, of course, in the execution of Louis Riel. Most people know about the execution of Louis Riel, but what they don't know is that there were 39 Indians who were also executed at the time that Riel was executed. There's a wonderful book written about this by Blair Stonechild called Loyal Unto Death. You ever want to read about it? It's a very interesting history, but it's an ignored part of our history. We all concentrate on Riel, and certainly his symbolism and his importance to the Métis people it goes without saying, but the reality is that Indian people were also caught up in the whole process of resistance. And the Saskatchewan resistance led to this 1885 amendment. But it effectively prevented Indians from doing any organizing politically to lobby the government of Canada to do anything. Well, if you can't organize publicly, maybe you can organize secretively. And so Indians would start to take advantage of the opportunities they had to get together in order to challenge the government. So in the prairies, the Sundance gatherings would have people in attendance in thousands. On the west coast here, the potlatch gatherings would also number into the thousands. And while the missionary societies who ran the residential school system had always opposed those ceremonies, saying that they were pagan ceremonies and they were preventing them from doing their work as Christianizing the Indians. The government of Canada had not really reacted to that, but when the Saskatchewan Rebellion occurred and the conspiracy laws were put into place, the government saw that it was possible for these Indians to get together in these ceremonies and at the same time as they were celebrating would also be conspiring. So they passed a law which said you can't have these ceremonies anymore. The potlatch and the sundances were specifically prohibited. But in addition to that, any gathering involving the wearing of Indian garb, any gathering involving the exchange of gifts, any gathering involving the use of traditional culture, traditional ceremonies, were all prohibited by the middle 1880s. And so these prohibitions against ceremony, these prohibitions against customs and tradition were intended to prevent conspiracies from occurring, were also intended to prevent the paganistic rituals that Indians were supposed to be following from being continued, and to make the assimilation and Christianization of Indians that much easier. But the reality is that what it did was it drove those ceremonies underground. It drove those gatherings into secret. And so even as a young person growing up, I was aware that there were people who did these ceremonies. There were people who conducted sundances. There were people who conducted shaking tent ceremonies and who did sweat lodges. But they did them way off in the bush, and they did them in secret so that the number of people who could attend and who could be informed by them and about them was limited. And I remember, in fact, when I first started going to sweat lodges after my son was born, I found out that there were people at a reserve near Winnipeg who did them, and I started to ask about going. One of the things that I was told was that if you want to be there, you had to come late at night. The first sweat lodges, in fact, that I ever went to were all held after midnight, and they were all held way off in the bush somewhere that was impossible to find unless you knew the route or had somebody who knew the route. And they didn't finish until just before sunrise, and then everybody tried to get home before the sun came up in order that they could get ready to go to work. That's the way they were held, even in the 70s. Done in secret by elders who had been raised to hold them in secret. Now they're done much more publicly, and it's not unusual in prairie reserves anyway to see a sweat lodge in someone's backyard. But there is still a considerable amount of resistance about that. So and we know what, of course, went on in the residential schools insofar as the treatment of language was concerned and customs and how children were raised. But one of the things that has done, I think, was it started to drive a wedge between the children who went to the schools and the elders back in the communities. so that these children coming back were less in contact and less in touch and less connected to the elders. But after many generations, I think you'd begin to see that impact. And it's reflected actually in the statistics. When we did the inquiry in Manitoba, one of the things we noticed was that overrepresentation in the justice system by Aboriginal people on the criminal side doesn't really begin to occur until after the Second World War. Up until the 1940s, Aboriginal people in Manitoba and in Canada generally were actually underrepresented in our jail system. We had about 9% of the population in Manitoba, First Nations only people in the 1930s, but less than 3% of the people being incarcerated were Aboriginal men, were Aboriginal people. And none of the women being incarcerated were Aboriginal women at that time. But after the Second World War, you begin to see a change, and there's a lot of reasons for that. But I think probably the most significant reason was that by that time, you're beginning to look at the 7th, 8th, and 9th generation of people who had come through the residential school system who had been raised and were trying to raise their children in an environment in which they have no contact and no knowledge of their traditions and customs and culture. And that culture loss is actually a cultural breakdown, because I don't think it has ever effectively been replaced by anything that Canadian society has had to offer. We've certainly seen an influx, an influence of the churches in our communities, but I think those influences and that presence is rather superficial. It hasn't really gotten to the core values of the people within the communities in which they operate. And the result is that children are being raised in a society in which they have very little concept of what is normal, what is right, what is wrong, from the essence of their being in a very personal and significant way. They are told what the rules are, they are told what is expected of them, but the models of behavior that they see are not imparting to them what those rules are. Excuse me. So by the time we started our inquiry in Manitoba, we were seeing overrepresentation rates on a massive scale. About 70% of the men being locked up in Manitoba were Aboriginal men. Aboriginal people represented about 12% of the population at that time. About 90% of the women being locked up were Aboriginal women, and about 3 out of every 4 young persons being locked up was an Aboriginal kid. And in the child welfare system, almost 90% of the child welfare cases involving kids being taken away from families involved Aboriginal kids. And so that certainly is reflective of tremendous problems. That breakdown, I think, is reflected in the way that family dysfunction is occurring in our communities in a significant way. And in particular, let me talk about one aspect of it, and only one aspect. I don't want you to think this is at all comprehensive. Sexual misbehavior in the family settings in Manitoba is incredibly high. And I, as a judge, was honored to work with the community of Hollow Water in the development of their Hollow Water Holistic Circle of Healing approach to things. And I'll explain to you, this model that they developed has come to be known as the Manitoba model. But it's one that you have to understand is unique to their community because of the way that they approach things. Hollow Water had a sexual offense rate that was enormously high, significantly high, because they had a very active social work group in their community. Aboriginal men and women who had gone to school came back to their community to work in their community with the specific purpose of identifying those kinds of issues and helping those kids in need. Many of them themselves had been victims of sexual abusing as they were growing up, and they were determined that they were going to help the young people in their communities who were experiencing that abuse. One of the things that they did was they did a survey. Hollow Water is actually only one of 4 communities. There's Hollow Water, Whole River, Manigatogan, and Seymourville, all in a very closed area. And those 4 communities comprise about 1,500 people. They did a house-to-house survey of everybody in those 4 communities with the intent of determining 2 things. One is, have you ever been the victim of sexual abuse And have you ever yourself abused anybody sexually? Now, they had to do it in a very careful way, but that was the purpose of their study. And what they determined was that 3 out of every 4 persons in that community, to the extent that, excuse me, that they were able to determine it. Remember, there are some people, of course, who wouldn't respond. But of those who responded, 3 out of every 4 persons who responded to that survey admitted that they themselves had been sexually abused. And 1 out of every 2 people, men and women, said that they had themselves sexually abused somebody else while they were growing up. That's an incredibly high rate of sexual dysfunction. And the court that took cases from Hollow Water actually didn't sit in the community. It sat down in Pine Falls, which was about 60 miles away. But the court regularly had cases on its docket of sexual offenders from that community who were being sentenced. And the sentences ranged from 15 months to 50 months. People would be locked up for that period of time, depending upon the nature of the offense and their circumstances. But at any point in time, in fact, during the period of study that they did, they had 12 people, 12 men from Hollow Water were locked up when they first started out doing this survey. They had 12 men from their community who were in jail for sexual offenses. And one of the things that they determined was that these 12 men and every other man who was going to go to jail was going to be released and come back to the community, and often without any treatment for the problems they were having. So they decided to do things their own way. They managed to persuade the RCMP to work with them and the local social service agency for the province, who then, with them, approached the Crown Attorney, who then, on their behalf as well, approached the judge who sat out there. And it was easy, that was me. But the community approach was they entered into a protocol, not an agreement, not a contract, but a protocol with the Crown, that the Crown would agree not to proceed with a case of sexual offending of anybody from those communities, so long as the person acknowledged his guilt at the outset and indicated his willingness to work with the community treatment program. And as long as he was prepared to work with the treatment program, then the community would allow the program treatment process to run to its completion, and then at that point they would make a recommendation to the Crown about what kind of a sentence they thought was appropriate. And then it was at that point that the Crown would allow the matter to proceed to sentencing. Now keep in mind that the Crown Attorney always took the position that they could not stay a charge in return for treatment. They were of the view that once a criminal process had been identified, if it could be proven, they felt they were obligated to take the matter to court. And so they were not prepared to negotiate because they felt that it would be too easy for an accused to say, yes, I did it, now I don't have to go to court. They wanted that opportunity for the court to have the final say. And so Hollow Water has done that now since the early 1990s. 91 was about the first 91 was the first case that they dealt with involving a fellow by the name of Seymour, who, instead of getting the jail sentence of 15 months, which the Crown would ordinarily have recommended, after completing the program successfully, was placed on, at that time, probation with certain terms and conditions. They have, the last set of statistics that I've seen is that they've dealt with about 120 cases in Hollow Water, all of sexual offending behavior, all with the exception of one involving men, one involving a woman. And in each case, they have managed to convince the court that a non-jail sentence should be imposed. So it's a community-based sentence virtually from the outset, with the exception of 2 cases. There have been 2 cases of people who have recommitted offenses once released. And in those cases, the men went to jail for their second offense on the recommendation of the community. Now, incidentally, one of the cases was actually interesting because it involved a young man who was mentally disabled, but not a person who could be considered not criminally responsible, but he had a mental disability. He had the mental age of a 15-year-old, but he was 38 or 39 years of age. But he just couldn't resist the advances of a young woman in his community who was underage. And it was admitted, I think, generally by all of those in the community that she was sexually acting out herself, but she had found a willing partner in him who was unable to stay away from her, even though the court had ordered him to on at least 2 occasions. Once as a condition of a probation order, and once as a result of a charge of sexual misconduct. So the next time that he was charged while he was on probation, he was actually sent to jail for a period of time, with the primary purpose being to get him out of the community. But the community has enjoyed a tremendous success with its approach because the recidivism rate, by their analysis before the program started, was somewhere around 50%. So they believe that about half of the people who'd gone to jail before the program started were recommitting sexual offenses back in the community, or offenses of violence. But with their approach, they've come to the conclusion that the recidivism rate is now just over, or about 2%. So they're very happy with the way things have gone. Unfortunately, I think they're losing their funding as a program. They've been funded as a pilot project to this point in time, and the Government of Canada and the Government of Manitoba have indicated, not indicated at least, that they're committed to funding it any further. So I think that's just an example of how a community-based approach can have a much better impact than the approach that has been taken elsewhere, and in particular by the usual approaches of sentencing that we were concerned about. And Gladue certainly talks about the need for us to understand that incarcerating people has never been the answer and is not the answer. We need to understand the importance of taking better approaches, and we also need, as a result of Gladue, to understand that this whole history that I've talked about, how it's influenced each and every one of us. It has influenced those of us on the Aboriginal side in every capacity, whether we're people who work day to day in our communities or whether we are people professionally trained working in an urban environment. It has affected us in all of those ways. But it's also affected all of the non-Aboriginal people in this society as well, because we have been trained to believe in a certain way, and you have been trained to believe in a certain way as well. So we can't begin to do things, continue to do things the way that we have done them, because we have done them based upon false ideas and false premises, and we need to understand that that has led to the situation that we're now facing. Incarceration rates since we did our study in 1991 in Manitoba have gone up. They've not gone down. And it's because the Manitoba government and the Canadian government as well, but the Manitoba government have decided that the option of doing things differently is just too expensive, and they're not prepared to spend the money. But they are prepared, apparently, to build new jails. We have a proposal now in Manitoba that they're prepared to build a new jail for women to replace the one in Portage Prairie. It's unfortunately, I think, a misguided bit of spending. I want to thank Roberta and the organizers for inviting me to be here, and thank you for your attention. I appreciate I've run a little bit over time, and it's important for us to allow the other speakers to have their say as well. I hope that some of the thoughts I've shared with you have given you some things to think about. I look forward to participating with you throughout the day. Miigwech.